Before we begin, can we just check Justice Rajesh Tandon sir's mic, please? Justice Rajesh, can you hear us?
Yes, I am here. Namaskar.
Thank you, sir. आप अपना वीडियो भी चेक करना चाहोगे एक बार?
ठीक है, ओके, ठीक है.
Yes, sir. बढ़िया बढ़िया. Thank you, sir. Vikrant sir, can we do a mic check for you too?
Yes, Siljo, this is Vikrant. Can you hear me?
Yes, sir. Clearly, thank you.
Yeah, you know, Siljo, there's been a clash of meetings with UNHCR where I am. So,
right,
yeah, but I'll be stepping out of that meeting to be here. Okay.
Okay, fine, sir.
Please.
Thank you.
Thank you. Thank you.
So before we begin with the session, first of all, good evening to one and all. Thank you for joining us on time for this Sphere India Academy's another webinar which we have planned on this very important day, International Day of Multilateralism and Diplomacy for Peace. This was actually yesterday, but we are commemorating it today with the panel discussion on international humanitarian law, its hopes and challenges. We have a very eminent set of panel with us today, starting with Professor Dr. Manoj Kumar Sinha. So Professor Manoj Kumar is a director and professor from Indian Law Institute. He has caught up in another meeting, so he will be joining us in a short while. Meanwhile, I would like to just give a basic intro about him for all our participants who have joined us. Professor Manoj's main area of specialization includes human rights, constitutional law, international humanitarian law, international refugee law, international criminal law, international institutions, etc. He has published extensively in field of international law, international relations, constitutional law, international humanitarian rights, and humanitarian and refugee laws in reputed national and international law journals. Prior to joining the Indian Law Institute, he was teaching at the West Bengal National University of Judicial Sciences as professor of law, and he also served the Indian Society of International Law as its director. We'll be welcoming sir once he joins. So next up we have with us Major General M.K. Bindal, who was a former executive director of National Institute of Disaster Management. So he was commissioned into the Corps of Army Air Defense in December 1985, an alumnus of National Defense Academy. Major Bindal is a graduate of Defense Services Staff College and has attended the prestigious Higher Command course at the Army War College, besides excelling in all other career courses in the Army. He has an academic background of defense strategic studies and defense and management studies. During his more than 3 decades of service, he has held important command and staff assignments. So I would like to welcome Major General Bindal sir. Justice Rajesh Tandon sir has also joined us today. He is a former honorable judge from High Court, Uttarakhand. So Justice Rajesh started career by practicing as an advocate in the year 1968. He has held several important positions under the Constitution of India. Justice Tandon was appointed as senior advocate in 2000, and then honorable judge of High Court Uttarakhand in 2004, and then presiding officer Cyber Regulation Appellate Tribunal Delhi in 2008. Justice Tandon has authored 4 books in law and has also been awarded prestigious Sahityak Puraskar on the famous book Muslim Vidhi in Hindi by government of UP. Welcome, Justice Rajesh. We have Dr. Umesh Kadam with us, who is a consultant of ICRC New Delhi with us. From 1980 to 1998, Mr. Umesh taught international law in various Indian law schools and colleges. In 1998, he joined the International Committee of Red Cross as a regional legal advisor. He worked for the ICRC for 20 years in South Asia, Southeast and East Asia and East Africa. He retired from ICRC in March 2018. Since then, he has been working as a consultant for international agencies, including the ICRC regional delegation in New Delhi, and as a visiting professor for international law in some law schools in India. He has published about 30 articles, research papers on international law, space law, human rights, and humanitarian law issues in India and abroad. Welcome, Dr. Umesh. We have our last speaker for the day, Mr. Ayan Chatterjee, who is heading the ED India Foundation. So that's a CSR wing of Sterlite Power Group, and he is also the key lead for sustainability within the ESG subcommittee of the group companies. Ayan is also heading Sterlite India Foundation's the strategic CSR arm of Sterlite Power. Ayan is a member of Global Collective for Digital Pedagogy and Socio-Emotional Learning set up by UNESCO. Ayan is a postgraduate in management from IRMA and holds a PGDM in human rights, international humanitarian and refugee laws. He has been in the sector for more than 2 decades, handling large-scale projects in both not-for-profit as well as private sector, launching new concepts, product lines anchored in ICT and innovations. Welcome, Mr. Ayan, for this session.
Thank you.
We finally have with us the moderator for the day with us, Mr. Vikrant Mahajan, who is the CEO of Sphere India. Vikrant comes with 24 years of versatile professional experience, having worked across sectors with government, UN, NGOs, corporates, academia, and armed forces. He is a passionate humanitarian and have been on the front line of most disasters in India and the region over nearly 2 decades. He has also been very active on global and national policy forums and represents on several interagency forums and board of many organizations. He comes with a multidisciplinary background in engineering, public administration, organization behavior, and law. He is a certified project management professional from PMI, Black Belt 6 Sigma, master trainer of CHS, Sphere, and other such standards. So with this, that was a brief introduction about our panel for the day. As mentioned before, our Professor Manoj would be joining us by 4:30. So over to you, Vikrant sir, for taking us through the panel discussion. Thank you. Vikrant sir, you're on mute.
Yes, am I audible now, Sudha?
Yes, sir, loud and clear.
Okay, thank you so much, Silja, for this introduction. And I think it's a very interesting topic today, and at a very opportune time that we are going to discuss this. On a day of multilateralism and global peace, that was yesterday. We as a group of professionals who the distinguished panel we have had it today, a mix of people with legal expertise, people with experience in army, military, the humanitarian agencies, especially the humanitarian agencies with a mandate like Icrc. It's a very, very distinguished panel we have it with us today, and a very interesting topic to look at the international humanitarian law. What is the hope and challenges in how this instrument can help us achieve global peace, and what could evolve from here. So we are in a very, very, very interesting space at this time to see as there in the recent past. If we look at, we catch up on some of the recent conflicts, especially the one which is there now in Ukraine. So there are in every conflict, as we say, there are two sides. And the two any conflicting parties, the two sides, with the two different views for various reasons they get into conflict. And but while this conflict is there, what sets the limits on the warring parties, and what defines the code of, maybe more of a code of conduct, for those who are in part of the conflict, in terms of putting limitations on them, is a tool is about international humanitarian law. And also within this this space, where do the humanitarians can intervene and how they can intervene. I think the required to get access to that space become the most important, and that's where the neutrality of the humanitarian actors in these space become of the prime importance. And within that, I think we all are part of the states. Like, for example, for us also, the Indian government, and rightfully the elected government is steering the foreign policy, vis-a-vis as India is concerned. And within that, in the interest as well as the stakes of the India in this whole thing is what we look at, and we respect that. But within that, framework. We have to look at the space for the people who get caught up into the conflict. How we see that they have access to essential humanitarian aid. How we see that their rights are protected, they are safe in this environment, and all those things is all about the international humanitarian law. And I think to discuss the aspects of this is, I think today's very distinguished panel with us is with the right mix of expertise also is there to take us through that. So with this background to today's discussion and the panel we already have who have been introduced, so maybe I think I'll start with the first set of question for the Dr. Manoj Kumar Sinha from the Indian Law Institute. I think we all heard about the kind of a distinction he has in the as far as the legal research study academic.
Come in. Manoj sir has not joined us yet. So we'll be joining in another half hour.
Okay, no problem. So maybe then in that case, I can start with the first question, maybe towards Major General Manoj Kumar Bindal, who comes with a distinguished army career, has been on a UN mission, and then post that also he has been leading the National Disaster Management. So General Bindal, over to you. Firstly, you can share a bit about your perspective on this the situation and the international humanitarian law in some of the recent conflicts. What do you see from as an army or a military person? Where have been the main what are your main observations in some of the recent conflicts, and what could have been done differently, and how do international humanitarian law comes up, and armed forces primarily you see that abiding to this law and reducing the impact on the civilians and other vulnerable groups who can get caught in the conflict. So looking forward to hear from you for your perspective. Over to you, Major General Bindal.
Thank you, Vikrant, and thank you, Siljo, for my introduction. It is a very good topic which has been chosen today because this is a crisis which we are all undergoing today in the world in some corner or other, and also because of the Ukraine crisis, these things are coming in limelight quite a lot. So I will talk about some violations which are taking place and why they are taking place, and what are the limitations because of which we are constrained. And there are two more issues which I will talk about in the question and answer session, so that because the other speakers will be talking about the legal provisions and various statutes of the various laws in detail. So I'm not going to go into that at this stage. Before me already, Dr. Manoj would have covered about all the legal provisions. So I'm leaving that out because whenever he comes, he'll cover that, and we will deliberate on those issues later. So right now, I'm talking about what are the observations of the various violations that take place and what can be done about it. Even though it is beyond the scope of this discussion today of factual description of the various conflicts which are being waged around the world, but I'll say it is suffice to say that war has continued inexorably to bring death, destruction, suffering, and loss in their wake. Today, civilians still bear the brunt of armed conflicts. Civilians have remained the primary victims of the violations of the International Humanitarian Law, IHL, committed by both state parties and non-state armed groups. Deliberate attacks against civilians, forced displacement of civilian populations, the destruction of infrastructure vital to the civilian population, and of civilian property are just some examples. Can we request someone to switch off their mic? I think someone's mic is on. Siljo?
Yes, sir, it's done. Please continue. Sorry for that.
Okay. So 1 second. So civilians, individual civilians have also been the victims of the violations of the law, such as murder, forced disappearance, torture, cruel treatment, and outrages upon their personal dignity, rape, and other forms of sexual violence. So they have been used as human shields also in many cases. Persons detained in relation to armed conflicts have been deprived of the basic rights, including adequate conditions and treatment, violent detention, procedural safeguards aimed at preventing arbitrary detention, and the right to a fair trial. So medical personnel and humanitarian workers have also been the targets of the IHL violations. In many instances, humanitarian organizations have been prevented from carrying out their activities, or they have been hampered in their efforts to do so effectively. There has also been this has also aggravated the plight of those whom they are meant to assist and protect. Attacks on the journalists and other members of the media is also a source of increasing concern today. So while the suffering inflicted in war has not changed, but in the past few years have been characterized by the growing public awareness of the international humanitarian law and its basic rules, and therefore of the acts that constitute violation of these rules. IHL principles and standards have been the focus not only of the usual expert debates, but also increasingly of intense and wide-ranging governmental, academia, and media scrutiny. Like today, what we are doing today. We are scrutinizing this particular law and its effectiveness. Heightened interest in and awareness of IHL must be welcomed and encouraged, bearing in mind the fact that knowledge of any body of rules is a prerequisite to better implementation on ground. 1949 Geneva Conventions have become universal, making the treaties legally binding on all the countries in the world. States, but on occasions, have denied the applicability of the laws to certain situations, even though the facts on the ground clearly indicate that an armed conflict was taking place. In many instances, states have attempted to broaden the scope of the application of the IHL to include situations that could not, or based on the facts, be classified as armed conflicts. So apart from the controversies over the issue of how to qualify a situation of violence in legal terms, there have also been what can only be called opportunistic misrepresentation of certain time-tested specific legal rules, and the tendency by some actors to point to alleged violations by others without showing any willingness to acknowledge their ongoing violations on their own has also been detrimental to the proper application of the law. The politicization of IHL defeats the very purpose of the body of rules. The primary beneficiaries are the civilians and the persons in combat. So the very edifice of the IHL is based on the idea that certain categories of individuals must be spared the effects of violence as far as possible, regardless of the side to which they happen to belong, and regardless of the justification given for the armed conflict in the first place. So a fragmentary approach to the law contradicts the essential principle of the humanity, which must equally apply to all the victims of the armed conflict. Parties to the armed conflict must not lose sight of the fact that, in accordance with the very logic of the IHL, politicized and otherwise skewed interpretations of the law can rarely, if ever, have an impact on the opposing side alone. It is often just a question of time before one's own civilians and captured combatants are exposed to the pernicious effects of the reciprocal politicization or deliberate misinterpretation by the adversaries. We are aware that the treaties of the humanitarian law, notably the Geneva Convention and the two additional protocols of the 1977, and then supplemented by the rules of the customary humanitarian law, the 2013 Armed Treaty, ATT, remain the relevant framework of reference for regulating the behavior in the armed conflict. So the basic principles and the rules which are governing the conduct of hostilities and the treatment of persons in enemy hands, which are the two core areas of the IHL, continue to reflect a very reasonable and pragmatic balance between the demands of military necessity and those of humanity. The main reasons for conflict is the failure to implement the existing norms, whether owing to an absence of a political will or to any other reason, but rather than a lack of rules or the inadequacy. And the law is just one among the many tools being used to regulate human behavior, and no branch of law, whether international or domestic, can on its own be expected to completely regulate a phenomenon as complex as violence. We have said because there are state groups, there are non-state groups, and individuals who will not be deterred from violating the rules regardless of the penalty involved. We have seen the suicide attacks targeting civilians is just a current case in point. So the law, if relied on as the sole tool for eliminating or reducing violence, must be understood to have limits. Political, economical, societal, the cultural and other factors that influence human conduct just as decisively must also be taken into account when contemplating comprehensive solutions to any form of violence. So with this, I will end here because I have more to say, but that I will take on at a later stage. Back to you, Vikrant.
Thank you so much, sir, for setting up the context. I think very right. You felt that it's the the conflict, very nature of conflict comes up, when the other forms of political and the other negotiations fails, and that's where the conflict comes on. And within that scene, we see the kind of violations are there. I think you stressed upon that. And what the law legally provides, I think we'll definitely go back to Mr. Kumar when he joined, Dr. Kumar when he joined. But then once we see the situation, conflict-like situation is there, and there are people, civilians and the other vulnerable groups, the even non-combatants, as covered by Geneva Conventions, who get caught up into this conflict. And in this situation, I think it's more important vital is to secure a humanitarian space and to be able to bring up the humanitarian initiatives there, humanitarian reach out to there. And for this, there's a one very, very special agency we have is the Icrc. And Icrc as with their mandate, and especially the kind of a special operations for the humanitarian one, they do. I think they on the front lines, I think they have a very unique experience, and perhaps I think it's here for us to understand from them that what role Icrc plays during international conflicts, and within that, what they see as the limitation or challenges of the international humanitarian law, but also what does it provides and what does it empower them to reach out to the people, vulnerable people, in the time of conflicts. So for this perspective, we have with us, one of the most suitable speaker, I think Mr. Umesh Kadam is a regional legal advisor for the Icrc. So over to you, Mr. Kadam. We look forward to hear your experiences.
Thank you, Vikrant. And I must first of all say that this is an excellent opportunity to share our views on a very specific issue, topic of international humanitarian law, which is at the center stage of debate currently, as General Bindala has just now pointed out. Speaking about the Icrc, the core mandate of Icrc is to protect and assist people affected by situations of armed conflict. And among these, the main categories of people would be civilians, wounded, even not only wounded civilians, but wounded members of armed forces. And then there are special needs of civilians like those who are displaced. There are special vulnerable groups like women, children, and so on, families which get separated from each other. So by and large, I would say the core mandate of Icrc is to protect and assist victims of situations of armed conflict, both international as well as non-international. Now, this mandate is given to the Icrc by humanitarian law conventions. There is a specific provision in the Geneva Conventions and the additional protocols to the Geneva Conventions, which refer to the work of ICRC in times of conflict situations. And therefore, ICRC is very closely associated with humanitarian law. And ICRC also believes that faithful application of this law will have the effect of reducing the suffering of people who are impacted by situations of armed conflict. And with this in view, the ICRC tries to promote respect to this law. Of course, what is most crucial in this connection is respect to the law when actually hostilities break out. Because on the battlefield, one of the most crucial issues is to ensure respect to this law on the part of parties to the conflict. Because if they do, there will be less violations, less suffering. And therefore, ICRC makes an attempt to promote knowledge and understanding of this law. And it has its own ways of ensuring respect, which I will explain you in a moment. But all said and done, ICRC see that the systematic development of humanitarian law in the form of very first Geneva Convention of 1864 and birth of ICRC, these were two simultaneous processes. And therefore, ICRC is intricately connected with humanitarian law. Now, coming to the very specific issue of what happens on the battlefield when there are violations. Now, ICRC in most situations is on the forefront. ICRC is given access in, and that is as regards international armed conflicts, parties are under an obligation to give access to the ICRC. They don't have a choice. They cannot simply say, no, we don't want ICRC. But when it comes to non-international conflicts, which are conflicts between the state and non-state armed groups, there the state may restrict access to the ICRC because it depends on the consent and approval by the state authorities. Because under the Geneva Conventions, the ICRC may make an offer of service in a situation of non-international conflict, and it is up to the state authorities to either accept it or refuse it or provide limited access, whatever it is. Now, once access is given to the ICRC, for example, and as I said, often ICRC happens to be the only organization which can reach out to the victims on the battlefield, because many organizations may not have that opportunity to go very close to the victims. Now, when ICRC is on the battlefield, it is quite likely that ICRC comes across violations. And what ICRC would do in such a situation? ICRC will not go on making public statements and publicizing the violations and so on. Rather, our strategy is to engage the concerned parties into a mutual confidential dialogue and to bring to their attention the violations and request them to bring an end to these violations. But unlike many other organizations, and especially I would like to refer to many human rights agencies whose strategies and whose methodology, is to highlight the violations committed by parties and create public opinion against the concerned state and so on. But ICRC doesn't indulge into that, because what happens is, in most cases, access is given to the ICRC with a tacit understanding that ICRC is not going to make public statements and embarrass us. And therefore, ICRC is often the only organization that is on the forefront. Now, another modality of ICRC's operations is that we work purely on the basis of neutrality and impartiality. And we look at the needs of people affected rather than to which party they belong. And therefore, for us, every person who is in need of support is a person who ought to be provided support, irrespective of the party to which the person belongs or the nationality or other similar criteria, because one of the basic principles is that of neutrality and impartiality on which ICRC undertakes its operations. So when it comes to conflict situation, we first of all have to assess the needs of the people. We have to see firsthand what are the needs of the people, and then accordingly plan our the relief activities. Now, in the process of working in a very delicate situation, a very precarious situation, we do face many challenges. Of course, first of all, as I said, access to the victims in a non-international conflict, states are not obliged to give us access. Rather, only in international armed conflicts, they have an obligation under the Geneva Conventions and additional protocols to provide access, but not so in case of non-international armed conflicts. And in many such conflicts, we are helpless because we cannot reach out to the victims because of lack of access. Then another dimension of access is whether we can have access to the affected people in view of security of the current prevailing situation. Because even if we want to work to help the people, but we may not be in a position to approach the victims because of the security conditions, because of the active hostilities which are happening, and therefore often we are a bit frustrated because there are people who are in need of support, but we cannot reach them out. So that is another limitation. Now, in terms of, as I mentioned, security, and again, we also have to look into the security of people who are affected when we undertake operations for them. For example, if people need to be evacuated, whether evacuation is safe or not, are there any safe corridors or not, whether the convoy which we would like to take is likely to be attacked. So we need to look into these aspects as well. Another dimension of security is security of the staff. In order to reach out to the victims, our staff should also be safe. And there are unfortunately situations which we encounter in different types of scenarios where our colleagues are taken as hostages, some are attacked, and there are a number of colleagues whom we have lost while they were providing relief to affected people on the battlefield. Because there are sometimes misconceptions on the part of some parties, and this happens more commonly in non-international armed conflicts, where armed groups, they do not know who the ICRC is, what we are doing, what our mandate is. It is easy to explain these things to the state authorities with whom we can engage in a dialogue, but it is extremely difficult in many situations to reach out to non-state armed groups. So coming back to the issue of security of staff, security of affected people, our beneficiaries, that also remains another major challenge. Then in terms of relief, the related challenge is the logistical. How can we bring in relief material in a place where there is an active conflict happening? We sometimes know the needs of the people. We would like to do something, but we are helpless. We are unable to bring aid and the relief material close to the victims of the conflict, maybe because of security, maybe because of breakdown in transport system and so on. Now, when it comes to relief material, another closely associated question is that of finances, of course. And unless we have adequate finances, we cannot engage in extensive humanitarian relief operations. And therefore, often we need to assess the needs, set priorities, and see what we can do given these limitations, given the constraints on funding. Often we launch emergency appeals, and the states, some international agencies, regional agencies, states which are in a position to donate, they do. And by and large, our annual budget has been in the range of 2.3, 2.4 billion Swiss francs. So this is also another challenge that we experience. In fact, General Bindal has rightly pointed out that awareness about humanitarian law is crucial, and there are more and more people who now talk about IHL, and this is extremely important for ICRC, and hence ICRC is also engaged in dissemination and training of armed forces, even dissemination in civil society contributes. And as you, General, pointed out about the role played by media people, because highlighting the violations is extremely important. It can bring international public opinion. There could be international pressure on the concerned states. Even domestic public opinion can be generated, and it also helps in ensuring respect. Sometimes the authorities feel constrained that because of this growing public outcry, we need to do something, we need to abstain from serious violations and so on. So, of course, another limitation in terms of IHL is, as General has rightly pointed out, that politicization is very common because humanitarian law is not a very strong system of law. It is like any other branch of international law, it is rather a weak system, and states have not created strong mechanisms to ensure respect to this law. And therefore, often we are frustrated. We come across situations where there are serious violations, but we are unable to do anything about that. But given these limitations, by and large, our experience as a humanitarian agency is that humanitarian law serves a very useful purpose. It doesn't provide mandate only to the ICRC, but it also facilitates work of other humanitarian agencies. And from that point of view, humanitarian law is extremely important in today's context. So with this, I would like to conclude my initial intervention, but I shall be really delighted to take any questions, and in the course of our question and answer session, I shall be happy to elaborate on some of the things I couldn't go into details. Thank you so much. Vikrant, you are muted.
Yeah, thank you. Thank you so much, sir. And I think we have been joined by Professor Manoj also now. But I'll come back to him so that he can catch up on the ongoing discussion already. And I see towards the end of it, as Mr. Kadam was saying, that I think this law has its own limitation, and the state actors, have not. There's firstly they need more awareness of it, and the law in itself has its own limitations also. Within the legal bodies and the custodian, I think we see is the possible role that can be played by the International Court of Justice, right? And again, what brings in from the International Court of Justice, I think recently also a resolution was adopted, but how much of it has been is a binding on the conflicting states, and what can really come from this? So I think we have for discussion on these aspects, I think we have with us, we're really lucky to have with us the Justice Rajesh Tandon, the formal honorable judge from the High Court of Uttarakhand. Sir, from your experience and the perspective, we'll really like to know how International Court of Justice intervene in these situations, and what are some of the judgments, in the past, and what have been the experiences which are promising, but where do we see limitations, and what can be the hope for future? If we are to advocate for the reforms or get organized, not only awareness, but I think the kind of panel we have here, what forward actions we can take it from here to see that the discussion continues and we see more empowered provisions for the IHL. So over to you, sir. We really look forward to hear from you.
Yes, thank you very much. I am thankful to Mr. Manoj Kumar Sinha, Director, Indian Law Institute, Mr. M.K. Bindal, and also Mr. Ayan Chatterjee, head of the foundation. First of all, I will say, because I have been the member of the Human Rights Commission at Uttarakhand, what is the human rights? human rights have been defined under Section 2D of the Prevention of Protection of Human Rights Act 1993. That means human right means the rights relating to life, liberty, equality, and dignity of the individual. What is the dignity of the individual? That has been borrowed from the Universal Declaration of Human Rights 1948. All are aware of that. And in that situation, India was one of the signatory, and that is why 1993 Act has come into operation, guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. International covenants, what are they? That is Universal Declaration of Human Rights, and that is also World Trade Organization law, practice, and policy. That is the main important factor. That is the World Trade Organization. If I come to a judgment of one of the old judgment of 2003, Kapila Hingorani's judgment, the word has been defined. His Lordships of the Supreme Court has said the right to development in the developing countries is itself a human right. The same has been made a part of the World Trade Organization. And in that context, the Supreme Court has said the United Nations has proclaimed the existence of a human right to develop. The right refers not only to economic growth, but also to human welfare, including health, education, employment, social security, and a wide range of other human needs. This human rights to develop is vaguely defined and so-called third generation human right that cannot be implemented in the same way as civil and political human rights. Now, the Supreme Court was aware at that time that how much a problem can arise for a so-called third generation of human rights that cannot be implemented in the same way as civil, politically human rights. Rather, it is obligation of the states and intergovernmental organizations to work within the scope of their authority to combat poverty and misery in a disadvantaged countries. Now, this is the crux of the 2003 of the Kapila Hingorani. And now the main task which has come for the International Court of Justice when the dispute arises between Russia and war. On March 16, the court issued its order, that is International Court of Justice, on provisional measures. The first determination made in the case, that is of Article 35(1) of the International Court of Justice statute. The courts governing the document provides that any state party to the statute is entitled to appear before the court under Article 93 of the disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. Ukraine asked the court to exercise jurisdiction on the basis that there is a dispute between Ukraine and the Russian Federation within the meaning of Article 9 relating to interpretation, application, or fulfillment of the Genocide Convention. In its application to institute proceedings, Ukraine argued that Russia's military action on and following February adjudge and declare that contrary to what the Russian Federation claims, no acts of genocide as defined by Article 3 of the Genocide Convention have been committed in the landmark. And now coming to the dispute between the parties, now one of the main things which the International Court of Justice has remarked with regard to the special military operation and Russian Federation on August 24, 22 is based on a false claim of genocide and therefore has no basis in the Genocide Convention, require that the Russian Federation provide assurances and guarantees of the non-repetition that will not take any unlawful measures in and against Ukraine, including the use of force on the basis of its false claim of genocide, order full reparation for all damage caused by the Russian Federation as a consequence of any actions taken on the basis of Russia's false claim of genocide. Ukraine therefore aims to disprove Russia's allegations of genocide and in doing so invalidated the latter's interpretation of the term. Indeed, this is the primary judgment it seeks from the court. However, full judgments by the court are rarely delivered swiftly, and now therefore the International Court of Justice has just observed the Russian Federation shall refrain from any action and shall provide assurances that no action is taken that may aggravate or extend the dispute that is the subject of this application or render this dispute more difficult to resolve. The Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order and then on a regular basis to be fixed by the court for its part. Russia did not attend the provisional measures. This is very important. Russia did not attend the provisional measures hearing, and while Russia is under no obligation to do so, the court can take formal note under Article 49 of the ICJ statute, its failure to do so. Just before my argument, there was a saying that how far the judgment of the International Court of Justice is binding, how far it has power to implement its own orders. This is the reaction that even the Russian Federation has not attended the court provisional measure and the provisional measures which were given by the International Court of Justice. On March 16, the International Court of Justice, led by the President so-and-so, returned its order on provisional measures in favor of Ukraine request after hearing Ukraine arguments on the established provisional measures test. The court first found the jurisdiction argument convincing, ruling that what constitutes a dispute is a matter for objective determinations. All these facts are there, and I am not criticizing anyone. I am not favoring anybody. I am just only saying that the International Court of Justice has power to implement its own decisions, but how far it is being obeyed, that is a question, to a debatable question, and nobody can bind any other state to follow that. But finally, the court also indicated that both Russia and Ukraine must refrain from any action which might aggravate or extend the dispute. And that is why I have cited before all that the Section 2D of the human rights has a conventional value. That is, Declaration of Human Rights is a conventional value. All these things, if you follow it, all are binding. If you don't follow, then nothing is binding. Even the court's order are disobeyed, then the contempt of court comes. And even after the contempt of court, everything goes in vain. Nobody follows it, and therefore we have to only adopt a provisional method. That is what is the human rights and what are the human rights provisions, and that is why the Supreme Court in 2003, I have just read before you, that the right to development in the developed countries is itself a human right. The same has been made a part of the World Trade Organization. Therefore, World Trade Organization, that is a precedence to be followed, that is a dignity to be followed, and therefore all these orders of the International Court of Justice may not be followed in truth, but the International Court of Justice is doing much justice to the states, and let the United Nations and all that be assembled to say that the International Court of Justice, what he says, that has to be, the orders have to be implemented under the Human Rights Act, because 1948 Declaration of Human Rights is a law which was participated by all the countries, and therefore it's a binding precedent on it. And the Supreme Court has further has said United Nations has proclaimed the existence of a human right to development. The right refers not only economic growth, but also to human welfare, including health, education, and employment, and social security. And therefore, this is a wide range of human needs. All these things are there, but these are not on the papers. Only the International Court of Justice always tried to emphasize the other countries also, and mainly Ukraine, to follow it. And now we are looking to that this is being followed, and this is being followed, and the International Court of Justice has full jurisdiction. It has power to resolve the ongoing dispute, taking into the shelter of the 1948 Convention and the prevention and punishment of the crime of genocide. These are the things, and the International Court of Justice has full power. If I take the example of the old Magna Carta, that is of 12,015, that was also an act which has bind all the nations, and thereafter the English Bill of Rights has come, that in 1689. Then the French Declaration has come in 1789. Then the US Constitution and Bill of Rights have come. These are the acts which have given birth for the two nations, which they may live peacefully, and they both may grow as a economic growth and for the human rights growth. And therefore, after this, the Universal Declaration of Human Rights have come, and about the civil liberties, civil citizens, and all that has come into force, and therefore we have to follow it. But nothing can be said about the favor or disfavor of anything. I remember on December 10, 1948, United Declaration of Human Rights was adopted by the 56 members of the United Nations. The vote was unanimous, although 8 nations choose to abstain. That is another matter. But the convention is that everything has to follow. We obey everything. And I can only quote one example of the Gita. मात्र कर्म अपने लिए करना बंधन है, संसार के लिए करना सेवा है, और भगवान के लिए करना पूजा है. धन्यवाद. Thank you very much.
Thank you so much, sir. And
yeah, thank you so much, sir. I think as you really shared, so there is this international law. It's empowered, it is an instrument, and there is the institution, International Court of Justice. But then the resolutions of the International Court of Justice itself is not binding on the states. and there we see the the violation, and that's where the limitations comes in. I think Dr. Manoj Kumar Sinha has joined us now in between this discussion and is very rightly at the right place. So, as we see in the case of the present conflict in Russia and Ukraine, Russia was not present for the hearing, and while the International Court of Justice has passed the judgment and the resolution. So within this machinery, and I think within us, all of this, we a group of informed citizens, a very eminent panel today here. We also have a policy of Indian government. India government's foreign policy also is another dimension to all this discussion and conflict there is. So within all this, the complex nature of the conflict and the interest of the people we have, who are caught up into the conflict. So what are the legal provisions available? A lot of that has already been discussed by Justice Rajesh Tandon. So we like to hear more from your perspective. And I think where is the hope in the future? Where do the law moves and the actors who are working in this space move forward? To bring more peace, more anti-war mechanism become more strong, and we are able to address the violations also. So we really like to hear from you, Dr. Manoj Kumar. Over to you.
Thank you very much. Honorable Justice Rajesh Tandon ji, Professor Umesh Kadam sir, Major General M.K. Bindal, Ayan Chatterjee, and our dear friend. I thank profusely Spare India for asking me and allowing me to accommodate me even in the between. And thank you for that you gave me an opportunity to hear Honorable Justice Rajesh Tandon, and partially I could hear Professor Umesh Kadam. But I had an opportunity to learn and under the guidance of Professor Umesh Kadam when it comes to the international humanitarian law. So I have a long association with sir. In the particularly, if anything I have learned international humanitarian law, it was largely because of pushing of Professor Umesh Kadam in 97, 98. Let me 2 points you have highlighted. You specifically pointed out or targeted towards me. So the target is that India's policy and anti-war. And then what I have gathered from that particular point, Indian policy, we have, if we see in the last, what we got through the press also, that almost 10 resolutions we have abstained, including the last one, which was very crucial, where Russia also expressed that abstention will amount to a negative vote. So will not consider. So the last one, that is the major important development which I see in the current situation, when a state which was instrumental in creation of the United Nations, Russia played very important role. Russia played very important role in the Nuremberg trial, the trial which was all the head of state were discussing, being a socialist country, but they said, somebody suggested, no, we gone for summary execution or lot of ideas, eye for eye, this kind of discussion took place. But finally, Russia's idea prevailed, and Russia says, we should have some kind of judicial trial, judicial, and that idea has shaped the Nuremberg. So Russia played also in the creation of the United Nations, Russia, France, UK, USA. So institution which created, and that takes you the important point in the preamble of the United Nations Charter, the word it says, it starts with, it says we the peoples of the United Nations. We the peoples of United Nations determined to save succeeding generation from the scourge of wars. So the states which created the United Nations taken a war pledge that we have to work together and not ever what world has witnessed twice in their lifetime, for the First World War, Second World War, not happen in there. So that promises which were given by the 5 permanent members and other 46 the foundation member, 51 countries were the foundation member of the United Nations. They are the original member of the United Nations, including India. They played very important. These 51 states have a wider obligation under international law and other things. I will stop here and I'll go back to the first India's policy, and then again I'll come back. So I see that Russia has a very Not is like an ordinary obligation, it's extraordinary obligation which Russia should have adhered to. Russia should have taken note of that. Coming to the India's policy, India is caught in a very difficult situation, and it has been shaped not only diplomacy, it has been shaped largely because of the factual support, or support time to time in a difficult situation. So we have been protected, we have been helped by the Russia on many occasions in the past, starting with 62, 65, and even in 71 war. It was, so there was instances, and subsequently also the economic and military dependence on the Russia. So it was very difficult to play safeguard. In one hand, we are also coming closer to the Western world. And earlier, when Indira Gandhi was the prime minister, so then when we have, for many years, we were clear that we are more close to the USSR than USA. And Pakistan was considered much closer to the United States of America. And that reflected clearly in the 1971 war. So when we look into that perspective, but Russia's past experience, present also continuing, so that played very important role. And India somehow it appears that they give very guarded expression, and they say, okay, we are not in favor. We are pacific settlement of dispute. So in one hand, when it comes to the vote, we come out, but when we make a statement, whenever government of India has said, okay, we justify the war, they want okay, we want urgent. So government always says, we encourage, we urge the both government comes to the table, negotiate, find out a solution. Ukraine suffering is very difficult. And when the Bucha crisis, carnage taken place, in that Indian government also openly condemned the and then say, this is the subject. So then the caveat has been added, we have to investigate, not to judge. So we don't know, but what happened is wrong. But an inquiry commission should be constituted. That report will come, then we'll go more openly. So some way balancing. So, but we have more or less the current prime minister, our prime minister, Honorable Prime Minister Narendra Modi ji, is trying to balance shuffling between the United States or Russia and Ukraine. So he's taking, and very good time for India has come that all big states are looking towards India, or asking India to play some kind of role, important role in this crisis. So I see the 10 times we have abstained from voting. Abstain means neither we are for nor we are against, but it's not negative vote, or nor it should be considered. But we participate. You can absent and abstain. So we are not absent, we are abstain. We participate in the negotiation. We discuss everything, and then finally we express our opinion. When it comes to the vote, we say, okay, we have full dinner, so we don't want to eat anything. We go out of the dining hall and say, okay, let the other people eat because they are hungry, as they like or dislike. So some way we participate. So we are there. Our views are written. Only when voting we have. So if you analyze our participation and opinion, so opinion has been expressed. So some way it's there. But I think recently also General Assembly soon, or might have been, I am not followed recently, that General Assembly is also going to examine about the veto power. Veto power, that is also crucial. So that there's just a scope of diluting the veto power of the Russia. So that will be a different situation. So this is the position which I see in a best situation. And to deal with this crisis, India's stand is more or less very correct. And we have very dynamic external affairs minister who had experience, practical experience, exposure, not on the politician. So he understands the nuances much better than all of us. But what we observe, I feel personally, it's a correct approach. Let's see how things progress in there. When we look into the the entire crisis, it's not International Court of Justice. International Court of Justice has limited. It's just Honorable Justice has mentioned. It's adjudicating, and then provisional measure, and then we have seen total disregard for the International Court of Justice in case of Nicaragua case, very important case where United States did not participate in any stage. And Lordship that time, just Judge Nagendra Singh, which was there, Judge Veera Mantri, they both played very important role. Somewhere disregard by the powerful states regarding the decisions of the International Court of Justice is common. and hugely available. So that we see that in some way, so in the conflict which Ukraine has gone there, Russia did not participate. Russia is not bothered at all. And if maybe like, if enforcement, as Lordship has mentioned, it can, if Security Council take note of the decision of the International Court of Justice, in some way, there is a possibility. We leave it that side, which very nicely covered by the Honorable Justice in detail, and he has done. What I feel, the entire crisis has to be handled by the body which is responsible. Which body is responsible? United Nations is responsible. United Nations is responsible, and the purposes of the United Nations, the why United Nations has been created. One, we say, to save the human being from the scourge of the war in the preamble of the United Nations Charter. But when we go the first purposes of the United Nations Charter, the first Article 1, Paragraph 1 of the UN Charter. So you have, like, all of you are aware that 4 purposes and 7 like principles are there under the United Nations Charter. So if I'll just examine 2, 3 and quickly, I think I have 5 minutes more to speak, and then so sometimes teachers have a problem. They don't know. I don't want to explain.
No, sir, please go ahead. I think it's really very interesting hearing you.
So you alert me, because I'm really sorry. Teachers have a very bad habit, like they just, the women, the moment.
No, discussion is the right place, sir. Discussion is the right place. We really want to hear more from you.
Okay, so what we look into, the right place is the who will do. So no state has power. So when sometimes you go in the class and the student says, okay, why India is not doing something against Pakistan? Why India? No, we can't do that, because we have to regulate ourselves. We are subject to the United Nations Charter. The Bible or Ramayana of the United Nations Charter is that is the law. That the law governs the conduct of the states, like in India and everyone. So we have to go. So I say, no, you can't do that, because Article 2, Paragraph 4. I'm just jumping from the one. I'll come back. Article 2, Paragraph 4, which says use of force is prohibited under international law against the territorial boundary and political independence of sovereign state. Article one of the articles say that all nations are equal, sovereign equality, principles of, so it doesn't matter how much economically you are strong, how much militarily you are strong. It's for the all states are equal in the sovereign principles of sovereign equality is there. So use of force is prohibited under international law, under the Article 2, Paragraph 4. So territorial integrity. So force is prohibited. Some way international humanitarian law has not gone into the nature of war, conflict, or prohibiting the war. What the objective is that mitigating the impact of the war, and as a sir has said, protection and care. The major thrust of the humanitarian is a humanitarian angle. It has brought protection and care under the international humanitarian law, and foundation is principle of distinction. The distinction between the civilian objects and military objectives, then combatants and civilians, and that has been elaborated under the additional protocol 1, who are civilian, Article 48. Article 43 is important, Article 48 is important, 50, 51, and so on and so forth. And then, so Russia is like, no, Lordship, Russia maybe one day, the right platform for the Russia will be, which you have been hearing. And I'm very happy the first time, like, many head of the state openly saying, Russia, like Putin is war criminals. Biden has said. So war criminals. So today we have a permanent international criminal court where individual is the subject. It's not the state. So like, like the trial of Charles Taylor, like the trial of the Milosevic, like the trial of the Sudanese president, Deputy Prime Minister of Kenya, all trial has taken place. So whatever today Putin may be saying, but there is a possibility when regime change, after 5 years, 10 years, because economic sanction will continue. Even war comes to end, economic sanctions will continue. Economic sanction will withdraw gradually the way Milosevic was surrendered. So one day, these European Union, NATO, and the United States will say, we'll lift the economic sanctions. Now he is no longer president. You hand over to the International Criminal Court. Let him face the music, because he has committed and killed a large number. So there is a possibility of trial. It may happen in 10 years, 20 years. It may not happen also. There is a possibility how the country saves, how the Russia emerges after this crisis, and how is the Russia takes a step further after Putin. If like even Putin lot of 5 years, 10 years, or 15 years, we don't know. But there is a possibility of made these things happen in there. Sudanese crisis happened in 2004. Trial, like, the 2009 it took place. Milosevic 1992, he was handed over almost 10 to 15 years later. So we have history. So I'm speculating in the Hitler could not realize. Hitler could not, he died himself. But there are a number of, so he was also happy in the 1941, 39, almost he annexed most of the European country, entered in the France, entered in the Spain, Poland, and other places. He might have not the thought in the 39 and 40, he will be like, one day he has to commit suicide. The way he was annexing the country, but the entry of the United States of America in the Second World War changed the entire game, and then things started falling. So here also, indirect entry of the United States is there, and which is very much visible. Anyway, we come to the first one, the Article 1, Paragraph 1, which says to maintain international peace and security. To maintain international peace and security, it says the United Nations to maintain international peace and security, and it says to that end, to maintain international, to that end, they can take effective collective measures for the prevention and removal of threat to the peace and suppression of act of aggression and breach of the peace. So the mandate is very first article, the purpose of the United Nations, and that can be taken under the Chapter 7, the enforcement measures. So no states, if you read it, so first is the United Nations, that if there is a threat to peace or any problem, Russia, that UN is the right body. But some way, unfortunately, what we are witnessing, that happened also in the 2003, when the 4 states, United States of America, UK, France, and I think Spain, they decided to go ahead without taking authorization from the United Nations Security Council. They did in the case of the first Gulf War in 1990. The Security Council Resolution 660 authorized UN forces, US forces, along with the 36 member states country, contributed to liberate Iraq, liberate Kuwait from the Iraq in 91st Gulf War. So so that action was legitimized. But the subsequent was in 2003, due to the opposition of France. France said he will veto, and that forced Tony Blair and others to go ahead with the Iraq without the permission. So that action was not correct, and always it being questioned whether your relevance of the United Nations, the power of the United States of America, these questions were there. I remember one thing which Tony Blair had said openly, the United Security Council of the United Nations is not functioning as a legal body. It's a political body. Decisions are more shaped on the political consideration, not on the legal consideration, on the other principles of the international law. That is there. So the responsibility lies on the United Nations under the Chapter 7, the crisis. Sure. But some way the UN is a little bit slow, or some way it has its own difficulties and challenges. We are saying it's not good. So I to conclude, I say that the right platform to address this issue is the United Nations, and UN should have taken. But that have not happened, so we'll wait and see. Now the visit of the Secretary General is taking place to the both countries. It may emerge something in future. With this, I thank all of you, and particularly Honorable Justice Rajiv Tandon sir for being here, and Professor Umesh Kadam and all others. Thank you very much.
Thank you so much, sir. Thank you. I think you really put it there where we wanted to take the discussion forward, is that there's a hope is. And I think both the provisions, enabling provisions which the law have, and the institution International Court of Justice, but beyond that, I think it is the UN Security Council where the reforms are needed, and even including the veto power. I think you addressed about this. There is, so that's where the perhaps more reforms are needed, and that's where even where we said about in future maybe the possibility of taking it as an individual, not just as a state, because state is again the group of institutions, and beyond that the entire people of the state. But it's where the taking it as an individual, and the case in the future, that's perhaps where the reforms and where the hope could be. And we see that these kind of provisions in future may make the law more empowering and ensuring more peace. But I think I take the discussion from here, and I think Manoj Sinha also said about is the India's policy. Where is it there? And very rightly brought out. I think India's guided policy under the able leadership of our Prime Minister, seeing it that where it is there and abstaining it. Maybe I think the people at that position have a right information and right decisions to take, and also the right mandate to take decisions for the country. But within that, I feel that India have always been the torchbearer of peace and also the humanity and the humanitarian imperative, and that's where perhaps we could do more. And I see where Sphere India comes up as a coalition of humanitarian actors in India, and many of us involved here. We have Icrc, and now Mr. Ayan is also leading more the corporate engagement in the humanitarian action over there. So, Mr. Ayan Chatterjee, as you're coming from a corporate foundation who's more and more getting involved with the humanitarian action or perspective around there these days, so what do you see? The institutions like yours and other humanitarian actors in India can play a role in this. Is there a position perhaps we can take along with the government of India, with our, the Ministry of External Affairs, to take this forward? And how else you see that? And I see there are other corporate entities of India who have a position there in Romania, in Poland. They have their offices working there. Many of the software giants working from there. So and they are interested to look at their own population in and around them, and what role they can play as humanitarians in this crisis. So we'd like to really hear from you, seeing your experience with a corporate foundation and also your background in international law. Looking forward to you. Over to you, Mr. Ayan.
Thank you, Vikrantji and Sphere India, for allowing me to listen to Major Bindal, Dr. Umesh Kadam, Dr. Sinha, and Justice Tandon. It was a great experience learning from them. And incidentally, very sincere thanks to Dr. Sinha, Manoj Sinha. He was my faculty, and I'm glad, although we haven't interacted much, but this is a good opportunity to interact again. Thank you for the question, Vikrant. So I will, as we are aware, a significant chunk of Indian, software and telecom business, one of our group companies is also active in that sphere and is exposed to the whole Soviet Belarus and, Moldova, Romania, and Ukraine districts. So there are stakes both from people of Indian origin as well as business interests which are there in that domain. But also from the humanitarian aspect, as you were just discussing, I will try to summarize very quickly because I'm also mindful of the time and overshot. There are certain aspects which I will take from earlier discussion panel, especially Dr. Kadam's. It's the whole aspect of neutrality. I think it's very easy to it's not easy to be in the legality of the aspect, so that is the UN domain. While in the Indian, in terms of IHL domain, it is probably more on the neutrality that each party and, trying to ascertain whether all the critical distinction, proportionality and precautions are, enabled and from either party. And very interestingly, now we are also seeing a lot of social media and other exposure, which is a new domain, because one way is amplifying the news in social media so that immediate points are taken across. But the other thing is how humanely we are treating prisoners of war, or how humanely we are treating civilians in such conflict zones, and whether that on either party we have heard instances where there have been some violations. So keeping the neutrality aspects, again, I wanted to bring just quick figures which address this particular conflict zone, and it is definitely an international conflict because two state actors are involved. So just in the first 17 days of April, actually 500,000, in fact 600,000 people have been registered by the International Organization for Migration, where they have been internally displaced. And this brings the total to almost like 8 million people who have been IDPs, internally displaced persons. And this total is more closer to about 13 million people who have been either displaced internally or across the border since 24th February. And the four
while I was trying to review the points for this thing, there are two ways we can look at it. One is what we can do currently or in near future in Ukraine itself, and what we can do with people around the region, that is the places where people have migrated to. So Poland has about 3 million refugees from Ukraine, Romania about 7.5 million or more, and Hungary and Moldova have about 1 million total refugees. So about 4 million refugees have migrated other than some other smaller countries. And I remember, Mr. Vikrant, you were also referring to some of the efforts where can we do something around these places which are safer to travel or bring aid to, and focus in a different way to the Ukraine region, which is very conflict and hazardous zone at the moment. So I wanted to bring that within Ukraine, I mean, as such, roughly about 15 million people are currently being reported by UNHCR as people who need certain kinds of assistance. And the similar kind of sets are also there in the outside, refugee countries where Poland, Hungary, and Moldova, they are working on that. In terms of those domains, there are roughly 20,000 Indian people also, people of Indian origin who are centered around these countries where refugees have been coming in. And the local embassy has been fairly active in recent past in giving safe travel to students who were earlier in Ukraine. And they have established decent relations with the local community and all. So this is one opportunity where we can enable these people of Indian origin to, through international coordination on various aspects, to kind of strengthen the aid. We definitely, the pharma companies are definitely doing their bit in terms of providing medicinal supplies. But I wanted to quickly, broaden and categorize the kind of immediate supports we can provide into 5 critical areas. And as Spear India is also very critical in the disaster kind of this thing. This is a human disaster, and we need to immediately, and we have our exposure and experience and technical competence in disaster management, and therefore such strength should be leveraged in this case also, although this is a few thousand kilometers away. But because of technology, a lot of things can be done independently, as well as we have some sympathetic people of Indian origin and embassies out there. So we should definitely contribute and coordinate these efforts. So one of the critical parts immediately should be health and nutrition, while I'm not focusing on surgical or more detailed kind of equipment-based support at the moment. But simple things like kits, diagnostic equipment is very important, as we understood in COVID and recent pandemic, that how critical small kind of easy to use diagnostics are very important, because only 30% of Ukraine population before the war had been vaccinated. So there's a large amount of people who are out there who are coming to new countries, and they need vaccination, they need other efforts. There's also a lot of nutritional supplement requirements, as I'm understanding from the UNHCR reports, and there are a lot of high energy biscuits or deworming kind of requirements that are happening because people are traveling to multiple days across the borders. Then we have child protection, very importantly, the helplines, the psychosocial support. Some efforts have already been started by UNICEF around that area to provide online digital counseling support to people who are actually creating safe centers for children, because people have been traumatized, people have passed through various indignities across the way, and we can do our bit to systematize, use cloud kind of support in creating such channels which are confidential, and also case management kind of requirements in child protection. In terms of also creating, a lot of children have been orphans or left from families. So we have our expertise now, lots of startups and other things in early childhood development kits, or a school in a box kind of kits. There are many such entities which are already there. These such efforts should be also focused that when the refugees are coming to the new countries, can we support them? Can we create such centers of or equip them with the right kind of possibilities? In terms of education, a large part of India, experienced the digital pedagogy and socio-emotional learning requirements in recent pandemic. And I think a lot of this can be leveraged with the right amount of curation, the right amount of translation, and creating some resource panels can be leveraged to help such large numbers. So there are definitely ideas which we can, probe further with the right-minded, entities. We can discuss and strengthen these further. Water, sanitation, and health, as we call WASH. So this is a very critical requirement at the moment, both in Ukraine and also in refugee centers. So access to safe water, access to wash supplies, dignity kits. These are some of the aspects which need immediate interventions. And there again, we can create. In fact, there were groups where we were there that the local Gurdwara and all, they have already started some efforts around this. And people are circulating that in WhatsApp to kind of help the refugee centers. The other part is the social protection. There's a lot of, as we are understanding, there are a lot of violations of human rights and other things happening. Now, how do we keep confidentiality? How do we log in cases? How do we bring case management rigor into the system? There's a lot of effort, and there's also cash benefit transfers being considered right now because people are not getting access to cash. So in either case, India is one of the leading pioneers in terms of payment solutions which are non-cash based, as well as big data and other aspects which can manage confidentiality as well as case management. So those are certain aspects where we can bring in certain CSR interest to help out. Very quickly, I still feel that and I come from more on the technology background, so therefore I keep on thinking on how technology can help. And it helped during the COVID pandemic. So I kind of identified 3 places where immediately we can support. And technology has the advantage of being able to remotely, collate lots of interest. So someone in UK, someone in volunteer in Romania, and someone in Bangalore can work together. So big data is something where there's a lot of potential to help the disaster exposed people, especially analyzing social media communication, financial transactions, and mobile phone activities to understand how people are moving and delivering the help where exactly it is required. So that's one. The second is one of our group company, as I mentioned, is in telecom, and it's good to see that all the 3 mobile service providers in Ukraine are active. They're also a group of 20 odd service providers in Europe who have waived off the roaming and charges for the refugees. So people migrating and using the same phone from Ukraine to neighboring countries are not being charged. They just signed the MVNO. Europe has signed an agreement to that, which European Union has endorsed. And basically, we are also they are also looking at distributing a lot of SIMs for people to communicate further, because there's a lot of loss and in terms of people losing their loved ones and they're trying to identify. So telecom, again, in terms of high call volumes and emergency hotlines, these are very immediate things which India excels in. We have done many such things in the past, and we can definitely leverage and extend these strengths to these people. And the last part, which will soon come, is the relief efforts, while kind of being sporadic now, will kind of get together and it will become immense or big. In such cases, there's a lot of sometimes accusation of corruption or governance. And in these cases, India again has strong governance, e-governance mechanisms. So therefore, blockchain and other such methods, so that transparency and measurability of the relief efforts can be brought in, will be an interesting aspect to look at, where again India's strengths can be leveraged. So in all, that was my submission to the panel, and thank you for the opportunity.
Thank you so much, Ayan. Thank you. I think very useful. I think as a humanitarian coalition in India, we represent on some of these global bodies, be it the Sphere Board, the Core Humanitarian Alliance, and also we partnering very closely with the Red Cross movement and UNHCR. The local coordination which is happening in Romania, Poland, and Moldova also gives. I think we definitely take some of these messages there and see how the support from the Indian diaspora and Indian corporate can supplement that. But more importantly, we take it through the Indian channels with the Indian Ministry of External Affairs, and we see that India as a state also become the flag bearer of humanity and humanitarian, and that part be part of the policy which the government of India is following. I think definitely we look at to that kind of a work and go ahead. And for that, the legal fraternity which joined us today, Justice Rajesh Tandonji, I think Manoj Kumar Sinha ji, and the military experience, especially from the very rich experience the Indian armed forces with the people like General Bindal here have with the UN and the UN peace missions and all those things. I think all these are the correlated competencies which are there in the country, and I think we see coming together as this exercise today is not and in itself. I think it's a beginning, and maybe I think the end is from here. We need to take some collective steps ahead. And from Sphere, I say that I think definitely we'll keep making our efforts from Sphere India side to have the discussion going on, and we keep building the collective agenda and collective actions, taking it forward. This is my moment definitely to thank all of you. But before that, before we take an end of the discussion, time is already over. I would like to open it up if somebody want to ask a question from our participants. Please raise your hand, and Siljo, kindly help me moderate the questions from the participants.
Sure, sir. Thank you so much. So as mentioned by Vikrant sir, this is an open platform we have for all. If there are any questions to be posted directly to any of the panelists, this is the time. As you're running short of time, you may quickly raise your hands or put it on the chat box.
Okay, Siljo, if there are no more questions, I think also the time is catching up. It's a moment from my side to thank our distinguished panelists, Justice Rajesh Tandonji, Professor Manoj Kumar Sinha ji. Thank you so much, Major General Bindal, Umesh Kadamji, most importantly Ayan, and everybody, Siljo, for coordinating it. And I'll hand it over to you, Siljo, for any formal vote of thanks and the final closing and some announcements. Over to you, Siljo.
Thank you very much, Vikrant sir. It was indeed a pleasure listening to you and to all our esteemed panelists. It was a very critical topic and very vital at this time, and it was the points which we covered here. We have duly noted all of it, and it has, as mentioned, it has really come out in the right direction, and we are really looking forward to take some of the key action points from here on, and we might be connecting bilaterally with you for getting some more better clarity on these things. Thank you to all our esteemed panelists once again, even though it was a short notice for all of you, but you made it out today, and it was our honor to have you here and to listen to each one of you. Thank you very much to all the participants who have joined us. बहुत शुक्रिया सबके लिए, and continue to be with us, and we are planning a lot of sessions in the coming month as well. We'll be releasing our academic calendar soon, and we'll be sharing it with you, hoping to see you all in the coming 3 days as well. Take care, have a safe evening, and see you all soon. Thank you very much.